Hi, everyone. This is Kate Vengraitis. I'm an attorney in the Aging and Disabilities and SSI units at Community Legal Services. I'm joined by my colleague, Pam Walz, who's a supervising attorney here at CLS in the Aging and Disabilities unit. We're so excited to have this opportunity to talk with everyone about the Fed, to answer questions, hear what people have experienced, and to share the knowledge that we've gained so far on how this fairly new assessment tool has been both developed, used in practice, and how to advocate for your clients. So we're going to start with the waiver application process, which recently had a little bit of a tweak. As many of you who may have been familiar with the old process know, there's been a change where there's now a home visit by the independent enrollment broker, who for Pennsylvania is Maximus, which is happening right off really early on, which is great. It's a big change that many people were advocating for years. So the way that somebody who is interested in receiving waiver services, or really, any long-term care, this should really say long-term care application process, is that they can call the IEB Maximus. The number is provided here. On this first call, the IEB is supposed to answer questions about what long-term care services look like. They then schedule the first home visit, and they're supposed to inform the consumer about all the papers that they might need to visit so that someone can prepare and get those. This is also the point where the IEB is supposed to ask the consumer who their primary care doctor is, or who the doctor is who can complete a physician certification form. For those who aren't as familiar with this, a physician certification form is a document that is presented to a physician. They indicate the diagnoses that the consumer has. They indicate their level of care, if it's a nursing facility clinically eligible, NFCE, nursing facility ineligible, NFI, or if they're ICF, which is intermediate care facility level. And they need to complete everything on that form, otherwise it will be rejected. So this is a very, very important piece of information. The IEB will ask the consumer who can complete this, and they will send the form directly to the doctor to return to the IEB. We wanted to make clear that there's also another way you can start the application process. Instead of just having the consumer call the IEB, people can also call their local area agency on aging, which is also known as the AAAs. And they're able to help assist people in beginning this process. They will connect them with the IEB. They can answer any additional questions. I think some people prefer this because it might move things along quicker, or if they have a good relationship with their AAA, they might be comfortable with that. We definitely see it work both ways. So that's another option. Another thing that could happen on this first call is that the consumer may be asked to select their managed care organization. So currently, both in the Southwest and the Southeast in Pennsylvania, we have community health choices in full implementation mode. For the rest of the state, which is known as the T, which is Zone 3, community health choices will be implemented on January 1st, 2020. So basically by the time the application process is done, anyone applying now would be in an MCO. And they have 3 MCO choices. These are AmeriHealth Caritas, known as Keystone First in the Southeast, UPMC, or PA Health and Wellness. It's possible this might not happen at this first call. It can happen at other times, but it's helpful to know that it could happen and that someone might want to consider what those options are. So the next step is the first home visit, and this is where we've seen the change. This used to happen later in the process. It now happens right after the call, which is really, really great because it helps ensure that consumers know everything they need to get. They have a lot of assistance in completing the application process. So this is where the consumer completes a lot of forms, but mainly the PA 600, which is the application for medical assistance, which is a necessary part of the application process. There are other forms that are connected to the PA600 that have to do with financial eligibility, which, depending on the consumer's individual situation, the IEB will also collect. And it is at this point, after the PA600 has been completed, that the IEB sends it to the County Assistance Office, also known as the CAO. And the CAO, as we'll talk about later, determines financial eligibility for long-term care. Currently in CHC zones, so the Southwest and Southeast, this is where the selection of managed care organizations would happen if it hadn't been done on the first call. Previously, in non-CHC zones, this wasn't happening, but it should be happening pretty soon, given the Zone 3 or Phase 3 implementation that's going on now. There might be other forms presented that have to do with the program options, but the main one is the PA600 and financial eligibility. Moving on to the big one, which is really, really integral to what we're going to talk about today. The third step is when the AAA, the Area Agency on Aging, comes to the consumer's home to do the home visit to administer the FED. This should happen shortly after the first step. There was a second step. It is scheduled by the AAA. They will directly call the consumer to find out when is a good time for them to come. The consumer may have anybody present that they wish. So if they want to make sure that they schedule it during a time when a family member or a caregiver can be there, that is completely within their right, and they should feel free to vocalize that. At this meeting, the assessor who contracts with the AAA will complete the FED assessment. We're going to talk a lot about what that looks like. What I'll say here is that these assessors are trained on how to use the FED assessment. They complete a 10-module online training program, which includes information on how to address each item on the FED. They are trained to look at these items as not questions, but a series of questions that they might have to ask to get the information, and encouraged to use a really conversational approach. And they cover in this training a variety of case scenarios about how to handle different parts of the FED. An important note here is that the outcome of the FED may not be available. And the reason is that it's only available if there's an internet connection and the assessor can submit the FED at that time. If there's no internet connection, they can't do that, and so they can't complete it and tell the consumer their outcome. There's no reason they shouldn't be able to tell them the outcome, but I think it's possible to imagine scenarios where they wouldn't feel comfortable, but it's important to note that they might not actually be able to if they can't connect to the internet. And also just to note that the FED outcome is just one step in the eligibility process. So it's someone found eligible on the FED doesn't mean that they're fully eligible for long-term care. After the FED is completed, the information goes back to the IEB. In order for the IEB to make a clinical eligibility determination, they must have two documents: the FED results and the physician certification, which we talked about in step 1 as going out to the doctor from the IEB. If the physician certification and the FED results don't match, for example, the physician certification says that the consumer is nursing facility clinically eligible, but the FED results say that the person is nursing facility ineligible, NFI, then the application will go to the medical director at the Office of Long-Term Living for review. Another situation in which this could happen is if the assessor disagreed with the FED results, and they have an ability to note that in the FED. At this point, if the medical director at OLTL agrees that the consumer is NFI, the Office of Long-Term Living issues the denial notice with full appeal rights. If the medical review finds that the person is NFCE, or both the FED and the physician certification indicate they are NFCE, the application moves on to the County Assistance Office, where they determine financial eligibility. The important timeline here is that the IEB must receive the completed FED and the physician certification within 86 days of the first home visit. So things have to keep moving And if they are unable to receive either by that 86-day time period, the application will be closed and they will have to start a new application and determine if information such as a new PA600 is needed. One thing to note is that a FED is good for a year, as is a physician certification form, but that there has been a lot of guidance from the Office of Long-Term Living that a physician certification form can't just be updated with a whited out change in date or signature, and that if there's any question that it's invalid, it will not be used to determine clinical eligibility. So the last step in the application process is for the application to go to the county assistance office. This will only happen for consumers who have been found NFCE. The county assistance office has already received the PA600, that's the Medicaid application. But it's possible that there are still financial documents that are outstanding that the CAO needs to review to determine if the consumer meets the income and resource eligibility. The waiver and nursing home programs are both have strict income and resource limits, which we're not going to cover in any depth really at this training, but it's important to note that this is where this determination is made. If any documents are missing, the county assistance office will send a notice to the consumer and they will say, we need to have this information by this date or your application will be denied. Once the county assistance office has all those documents, it has to issue a PA-162, which is a notice that will have either an approval or a denial of the application. This will also have full appeal rights. This needs to happen within 90 days of when the IEB starts the application. And if there is no decision issued within 90 days of when the consumer starts the application, they can ask for a fair hearing. The county assistance office will be the entity that sends this notice, the 162, to the consumer, and they will also send it to the IEB and the managed care organizations for all the parts of the state where CHC has been implemented. The only other note about this is that, just so for those who are curious about the inner workings, once someone is found NFCE, the IEB triggers this process by sending a form called a 1768, which requests waiver determination based on financial eligibility. So most of the information has already been transmitted from that initial PA600, but it's possible information is missing. For those of you who've worked on these, you know that many, many financial documents can be required at this point, as there is a look back period at people's bank statements, transfer of assets, which can be very cumbersome to consumers. That is the end of the fairly quick review of this application process. We will gladly take questions at this time if anyone has them. You can also feel free to ask questions later. And you can also always feel free to email or call either Pam or myself. I'm gonna give people a couple seconds. Oh, yeah. How long is the look back period? That is a good question. So when you apply for long-term care, you are asked to provide 5 years of bank statements, which is really a lot. And our understanding from working with many clients is they find this to be very, very intrusive, and the level of scrutiny feels sometimes a little unfair. But yeah, 5 years, and this is looking at if people have disposed of resources, if someone is giving away money to try to become eligible for long-term care services. This is especially important to see if people are giving away, it can be cash, stocks, anything, especially if you're giving away property for less than fair market value. This is really important. That will cause problems. We can't get into the details of this, but if you are working with anyone who is looking to apply or thinks in the next 5 years that they might need long-term care, if you are not familiar with this, please talk to us. But the basic gist of it is that there can be penalty periods for disposing of assets, both for the value they are and for less than fair market value, and it's a really tricky area. Any other questions?
While we wait to see if there's any other questions, attorneys that are requesting CLE credit for your participation in the webinar today, I have just launched the first of the pop-up boxes with the poll question on. Please respond. You'll have 2 minutes to do so. And it doesn't look like we have any questions so far. So feel free to go on with the training whenever you're ready.
Okay, great. Hi, this is Pam Walz, also from Community Legal Services, and I'll be talking about the next few slides. So I want to start out talking about the Fed by talking about what the definition is for NFCE. Pennsylvania has a definition for NFCE, which is here in this slide, it defines NFCE as an individual who has an illness, injury, disability, or medical condition diagnosed by a doctor, and as a result of that condition, they require care and services above the level of room and board, and a physician has to certify that the person's NFCE, and the care and services are either skilled care as defined by the Medicare program, or health-related care and services that may not be as inherently complex as skilled nursing, but which are needed and provided on a regular basis in the context of a planned program of healthcare and management, and were previously only available through institutional facilities. So I wanted to point this out because while the Fed is the tool that OLTL is using to determine eligibility, it's not actually a regulation. This is, the Fed is intended to determine whether people meet this definition. But you should remember that this is actually the definition. So one option available to you at a hearing is to argue that the person meets this definition. In the past, we've had cases where we had to prove that people were NFCE, and because this is the definition, this is what we used. And I just invite you to note that the language is really broad. There's an awful lot that you can do here in arguing that your client meets this. And we'll talk a little bit more about that when we talk about hearings. This definition is derived from two other definitions. One is the definition in the Pennsylvania regulations that defines who is eligible for what used to be called intermediate care, facility level of care. And the second definition is the federal Medicare regulations, which define who can get Medicare coverage for skilled nursing facility care. I also wanted to give just a little bit of history and background on what came before the Fed. So until April of this year, the tool that was used by the AAAs in determining whether people met the NFCE level of care was a tool called the LCD, or the Level of Care Determination tool. It was a much longer set of questions that asked for a lot more medical information. It was about 24 pages long. It took an hour or more to complete, and it asked for all of the person's medical diagnoses, their medications. It went through each body system and asked whether the person had any impairments in that area, and for some information about how those impairments were managed. It also had a short cognition test called the SLUMS, and so a little test about the person's cognition. And it asked questions about things like whether the person was at risk for falls and how long they could be left alone. And then it also had a section asking for the person's need for help with activities of daily living and also about their mobility. So it was a really full assessment that gave assessors a pretty complete picture, or was intended to at least, of the person's conditions and their functioning. Then it called for the assessor, after they completed all this, to use their professional judgment to determine whether the NFCE definition was met. The department felt that there were several problems with this. First of all, they felt that it was too subjective. They were worried that that assessors might feel badly for people and might kind of find them NFCE because they felt badly for them. They were also concerned that they felt that the rules were not, that the outcomes were not uniform from assessor to assessor or from county to county. And in fact, CMS had concerns about it as well, and the department said that CMS actually withheld funds at a certain point because of this. So the department decided to make a change and do something about this, and they convened a stakeholder group. and settled on creating a new type of tool drawn from something called the Inter-RAI. So Inter-RAI is, first of all, an organization. It's a consortium of researchers and healthcare practitioners associated with the University of Michigan, which creates instruments and tools that are intended to use a research-based approach to decision-making about eligibility for long-term services and supports and other kinds of support programs for people with disabilities. And also for deciding how much services people in these programs should get. In other words, what kinds of services and how many hours. The tools that Inter-RAI creates are copyrighted, and states can seek licenses to use them. And a number of states across the country do use them in administering their Medicaid-funded LTSS programs. In fact, here in Pennsylvania, the 3 CHC MCOs are using something called the Inter-RAI Home Care Assessment System, which is one of their instruments, to do their comprehensive assessments of each CHC participant. And they use the results of this assessment as part of their person-centered planning process and to develop service plans. It's a long assessment with lots of questions, and the answers to the questions are designed to inform the service planning process, which has to be person-centered and individualized to the person. But there are also Inter-RAI instruments which can be used to determine functional eligibility for LTSS programs, and that's what OLTL decided to use. So DHS contracted with a researcher at the University of Pittsburgh and with the Inter-RAI consortium to take a small subset of the questions from the Inter-RAI Home Care Assessment Instrument and create a tool to determine level of care eligibility for LTSS programs. It's a really different approach from what we had before with the LCD. With the Fed, the focus is on people's functioning and really not at all on their medical conditions. The Fed doesn't ask at all about what the applicant's medical conditions or diagnoses are, but rather it just asks about what help they need in several what they call domains of functioning. So the domains are what Inter-RAI sees as the main areas of functioning that are supposed to be indicative of whether people need supports to be able to remain in their homes. And the domains are, there are 5 of them, are activities of daily living, which includes bathing, personal hygiene and dressing, toileting, eating, mobility, and cognition. So the questions are all, or many of the questions are about these areas. The Fed, which they created, is much shorter than the LCD. And this is seen as a plus in OLTL's view because they wanted something that didn't take an hour and a half to complete. We were really concerned about how few questions there are, and what Inter-RAI would say about that is that their research says that the answers to this limited set of questions about these domains tells you everything you need to know, and that people who have other needs that they're not asking about are already going to score high in response to other questions, and that the questions that are actually in the Fed pick up sort of stand-ins for these other issues and tell you what you need to know. Another thing to know about the Fed is that not all of the questions get scored. There are about 50, and I shouldn't call them questions, they're called items. There are about 50 items, only 20 of them actually get scored in determining eligibility. Another thing about the structure of the Fed is that the way the Inter-RAI structures its instruments is that it asks people and it explores what their functioning has been in the 3-day, what they call the 3-day look-back period, the 3 days prior to the day of the assessment. So it doesn't ask, generally what help you need. It asks, in the past 3 days, what help the person needed. And this is something that's been a huge concern for advocates across the country, because what if somebody didn't have help during that period of time, so they didn't actually perform that function. They weren't able to bathe because there's no one there to help them. How is that handled? And also, one of the questions, for instance, is about wandering. So what they ask is whether the person wandered in the last 3 days. Well, people who wander don't necessarily do that every other day, but it's, you know, if they did it a week ago, that's still a huge cause for concern. So this 3-day look-back period, which is in the structure of all of InterEye's instruments, has been really controversial and can be problematic, and is something to watch for. In developing the Fed, DHS's approach was that they weren't changing the definition of NFCE or the standard that people had to meet to become eligible. And in fact, in developing it, they called the LCD. They said that they were going to keep it as the same standard as the outcomes from the LCD, and they called the LCD the gold standard. It was the thing that it was indicative of whether people were NFCE. So just quickly, I just want to talk about what they did connected to this. In order to determine whether this new tool they were developing, the Fed, used the same standard, they did a little bit of testing. They administered both the LCD and the Fed to 100 applicants, and then they looked to see whether the outcomes were the same for the two tools. And the answer was not exactly. At the highest and lowest levels of impairment, the results matched up. So the most impaired people were found NFCE using the Fed and also using the LCD. And people who had very little needs were found NFI using both tools. But in the middle, it was about 50-50. And this raises real concerns about the validity of the Fed. We had discussions, pretty extensive discussions with DHS about our concerns about that. And one of our big concerns was that many of the questions that didn't even count seemed important, including questions about activities of daily living. You know, in my experience, a lot of our clients who come to us for help the first thing they need help with is ADLs like bathing and dressing, while the ability to eat and toilet independently is something that a lot of people manage to hang on to until, you know, for a long time. So in response to some of these concerns, DHS did make some changes to the Fed scoring, including counting ADLs, and they also changed the scoring mechanism. So let's talk just a little bit about the Fed tool itself. It's got sections on cognition, mood and behavior, functional status, continence, and treatments and procedures. And I'll just say that that last category doesn't count at all toward the scoring. On cognition, there are items that call for the assessor to check the person's short-term memory by asking them to remember something after 5 minutes. And another item where they check the person's ability to perform multi-step tasks. And they also check to see whether the person seems to recognize their caregivers and familiar locations. This cognitive piece has been a real concern. It's much less in depth than the cognitive assessment that was on the LCD. But what OLTL said was that while there was a whole test called the slums on the LCD, assessors frequently skip that assessment. So they think that just having these 3 items is better than what they had before. So here's a page that shows you a page from the Fed itself, and that is one of the 2 documents also that we emailed to everyone yesterday if you want to take a look at more of it. This is page 3, and it's section D, which addresses activities of daily living. So if you look at it, you can see that there are here under section D, there are items A through I, which ask questions about all the different activities of daily living. It asks how the person bathes, how they perform personal hygiene, how they dress their upper and lower body, how they walk, how they move between locations on the same floor, how they transfer onto or off of the toilet, how they use the toilet, and eating. And then each of these items is scored on a score of 1 to 8. And if you look at near the top of the item under number 1, you can see the scale of the scores from 0, which indicates that the person is independent, 1, which is also independent but set up help only, 2, which is supervision, 3, which is limited assistance, all the way down to 6, which is total dependence, and 8 means the activity didn't occur at all during the 3-day look-back period. So the assessor is supposed to go through each of these items and use a combination of asking the person, asking other family or caregivers if they're present, or asking to demonstrate if it's something that can be demonstrated, or if there's some question about whether the information being given is accurate. And then they score them using the 0 to 8 scoring here for each item. I want to say just a little bit more about the 3-day period. One thing that we were concerned about the 3-day period was, what happens if the person during that period of time needed help but didn't have it, which would happen a lot, you would think, because these are people who are applying for services and may not have help. We were concerned if the assessor asked what help they received, but they didn't have any help, that the need for help in that area might not get picked up. We raised this with DHS and talked with them about that, and they've agreed that what the assessor is supposed to ask is what help the individual needed, not what they were able to receive. So this is, I think, an important thing to watch and make sure that assessors are doing, and to make sure that this is the questions being asked in your client's cases. Assessors can review medical records if they're available, and they're supposed to ask family members if there's any indication that the answers that they're getting from the applicant may not be completely accurate. For example, if you have a person with a diagnosis of brain injury, or they have dementia, and there's some concern that they may be understating their needs, or that perhaps they can't fully describe their functioning. And this is especially a concern here because the assessors may not know all of the person's diagnoses, especially if they don't have the physician certification form available. So after all the items on the pages of the FED are completed, the responses are scored using something OLTL calls the FED Tool Translation Matrix. And so, here is that translation matrix, and it's the other document that we emailed yesterday. This is the tool that is used to determine the scoring. So if you look at it, in the first row along the top are all of the items from the FED which get scored. The rest of them don't count. So if you look, the first column A has item B1, cognitive skills for daily decision making. Column 3 has the ADLs that we were just talking about on that page of the FED that we looked at with bathing and personal hygiene. Then the column down the left side has all the possible scores from 0 to 6. And I know some things get an 8, but 8 means it wasn't performed at all. So here they just score from 0 to 6. And so these scores down the side correspond to those scores that we were talking about before. I'm going to go back from 0 for independence to 6 for total dependence. In the boxes below each item, it says what scores count as either a partial or a full deficit. So, for example, in column A for item B1, which is about cognitive skills for daily decision making, if the person got a score of 2 to 4, they're considered to have a partial deficit. And if they got a score of 5, they're considered to have a full deficit. Or if you look in column E, which again is about bathing and other ADLs, a score of 3 to 6 on any 2 of the sub-items, which they call bullets here, is a partial deficit, while a score of 3 to 6 on 3 or more of those bullets counts as a full deficit. So you need to go back, so you can get a copy of your FED, I should say, by requesting it from your client's FED from Maximus. And you want to go to that to see what score your client received for each item. And then you can look at the translation matrix to see how many of their responses got them either a full or a partial deficit. And to be found NFCE, the person needs to have either a full deficit or 3 partial deficits. And you can see at the bottom of the page, it says that there. A problem in figuring all this out is that the printed out version of the FED that you get from Maximus doesn't say what number corresponds to each response. So it'll just say, for instance, it'll have the independent box filled in for an item. It doesn't have the numbers there to indicate what score the person got. So I've been handling that by going back to the blank copy of the FED, which we emailed yesterday, because it tells you at the top of each item what score is associated with each response, so that you can use that to look at the FED translation matrix. As Kate was saying earlier, if the assessor disagrees with the outcome of the FED, they're able to indicate that in a text box. And they can also add notes in text boxes at the end of each session if they've got any observations that they think are important and they want to make a record of, or want the medical director to know about. All right, so we're going to stop now. It's a lot of information. I want to stop and see if people have questions.
While we wait for questions, I am going to launch the second poll for attorneys requesting CLE credits for the webinar. Please just click yes or no on your screen. And if you have any questions, please type them in the chat box, which can be found if you hover your mouse on the bottom of your screen. Anybody have any questions?
Yeah, we're happy to answer questions about how the FED items are answered, or the tool for the translation matrix, which is not difficult, but it takes a little bit of looking at to understand how it works. All right, well, we could move on, and then if in the meantime, if people have other questions, they should feel free to type them in, and we can go back.
Hi, this is Kate again. I'm going to talk briefly about two parts of this process, the medical director reviews and reassessments. So we've already covered medical director reviews a little bit in indicating that they are triggered when the physician certification and the results of the FED are not in alignment, meaning one says NFI and the other says NFCE, or if, as Pam just explained, the assessor indicates in the outcome box at the end of the FED that they disagree with the result. So either of those things could trigger the medical director review. This can't happen until the physician certification is received, because clinical eligibility cannot be determined until that has been completed. What's helpful to note, but also we have the caveat that we're not exactly sure what medical director review looks like. It is our understanding from the cases we've handled that there is no notification to the consumer or their advocate, if someone's representing them, that medical director review is happening. So to know that it's been triggered, you really have to stay on top of the results of the FED, which you should be able to get by contacting Maximus as long as you have some information indicating that your client is allowing you to receive their information. They should be able to tell you shortly after the FED has been completed what the result is. So if you know that there is an NFCE physician certification and that the FED was NFI, that case is going to medical director review. It sounds like this is happening pretty quickly, which can be concerning because it means there might not be enough time to really submit any materials. But we have been told by OLTL and by Maximus that advocates and consumers can submit information directly to OLTL, to the medical director, in order to argue or to show why the consumer meets the NFC definition, despite what the Fed said, or that the Fed was, to argue that the Fed was wrong. So any records that you have, any information that can provide some context. I think where we're seeing some issues here is that the current sort of mantra is that the FED is about functional eligibility. Just diagnoses alone and medical conditions alone isn't what controls. obviously what controls is the definition of NFCE. So what matters is how someone's medical condition impacts them. But what we're seeing is that it's possible that medical conditions can have a number of impacts on someone's functional limitations, which may not be captured by the Fed. And to the extent that you have records or documents that can articulate this, or as advocates, you want to submit an explanation, OLTL says that they are open to receiving those, and it could be very helpful to the medical director, Dr. Appel. I also see that we have 2 questions that have come up. So once we get to the end, we're close to the end. So I think we're probably going to hold on to those until then. But thank you for the questions. Keep them coming. So reassessments are supposed to take place annually, and this is the requirement that that the Office of Long-Term Living has, that we determine if someone remains functionally eligible. For the parts of the state where CHC is in place, these have been happening when they come up for an individual by the Community Health Choices Service Coordinator. For the places in the state where we have not yet transitioned to community health choices, these are being done by the Aging Well assessors or people who contract with the local AAAs. So the difference between the reassessments and the initial eligibility determination is that a physician certification is not obtained. Even though they're only good for a year, they're just looking at the Fed. One thing that we have looked into is what happens if somebody is in a nursing home already. So if they are in a nursing home, as if they are, in the community, the assessor can review medical records. What we're hearing again is that because the focus is on functional eligibility and not, or functional ability, and not just medical condition, there doesn't seem to be as much of a initiative on the part of assessors to look at this. So this is something that we're really encouraging advocates to be involved with to the extent possible, to make sure that records showing sort of ongoing issues, especially those that might not have come up in the 3-day look back, are being made clear to the assessor and, if necessary, to the OLTL medical director. All right, now we're moving on to having some technical difficulties. There we are, on to the appeal process.
All right. So let's talk a little bit about appeals in this area. The functional eligibility denial notices are issued by OLTL right after the Fed determination, and it should specify whether the reason for the finding of ineligibility is due to the physician certification saying the person was not NFCE, whether it was the Fed, and it should say if there was a review, if those two were in conflict and the medical director reviewed it, it should say that the medical director reviewed it and found that the person was not NFCE. And that should give you some idea of what the issues are. The first thing I think to do in this situation is to get information from Maximus. And you'll need a HIPAA compliant release, and you can send it to Maximus and ask for a copy. In particular, you want to get a copy of your client's Fed and physician certification. There's a hearing packet which Maximus has been sending us that you can request, and it'll have the Fed, the PC, and most recently we got sort of an odd document that was labeled hearing information, which was supposed to have information about the process and eligibility, but instead had sort of confusing text from various waivers, and it seemed like some of the information was out of date. So you may see that. We've asked OLTL what's going on with that, and hopefully that will become a more useful document at some point. If you want to get this from Maximus, we found the easiest way is our contact there, Mary Stoneroad, and we can share her contact information with you if you need it. She's really good about getting back with that information, which will give you a starting point for figuring out what is, what happened in your client's application. A couple of things to think about doing before a hearing are, first, if you interview you'll want to, of course, interview your client and ask them a lot of questions to try to determine what needs they have and that are relevant to a finding of NFCE. And if you get the sense that the FED that was performed didn't accurately pick all of that up, you can ask Maximus and OLTL to do another FED. It's particularly easier to get them to do it if you can argue that something has changed, that the person's deteriorated, there's been some change, or that there was something wrong with the first FED that meant that it wasn't really accurate. And we've had a number of cases where the first assessment really failed to pick something up, and then we've talked to our client about the importance of fully describing all of their needs and what's important, and that has in some cases meant that a second assessment picked up more and meant that the person was found NFCE. Another thing is to do pre-hearing, as Kate was describing, is to try to get medical director review. Especially you could do that if there's a conflict between the physician certification and the FED, and it's helpful to try to get more information into the medical director, either medical records or letters from doctors explaining the person's needs, to try to enable him to have a fuller picture as he reviews it. In some cases where there is not a conflict, well, even if they're either way, in some cases we've pushed for physician review just because it really seems like something had gone wrong with the FED. For instance, if the FED was really short or completely failed to pick up on major issues that were there. If you get to the hearing, at the hearing, first of all, just in terms of who will be there, there will be an assessor there whose job, the assessor who did the FED will be there, and their job is to explain how the FED was scored. So in other words, how did the consumer answer the items? The assessor can also indicate whether they agreed with the outcome or not. In addition, there will be what's called a subject matter expert there, and their job is to explain to the ALJ and to the appellant how the FED functions and how the various responses affected the outcome. The doctor involved in the medical review doesn't generally come to the hearing. So at the hearing, you can argue and present evidence that the client's needs weren't accurately captured on the FED, and try to make the case that they actually do have 3 partials or 1 full deficit. Medical records or doctor's letters may be helpful. If you can get the doctor on the phone to testify, that can be very, very helpful. And one thing I think a number of us have had the experience in doing these hearings is sometimes in the course of putting on this evidence, the ALJ or Maximus will decide that it seems like it would be appropriate to get a new assessment, and it's possible that suggestion will come up at some point during the hearing. And so that is the way sometimes these appeals go, with an agreement to continue the hearing and do a new assessment, then see how that comes out. Keep in mind that even if the FED is really not working for you as a path to proving eligibility for your client, you can always argue that the NFCE definition is met. And again, that's really broad language where you can argue that your client has a disability or a condition that means that they have needs above the level of room and board, and that they need a planned program of care as described in that really broad language. In the past, we had a number of cases where we ended up having to do this, and we were able to talk doctors sometimes into getting on the phone and saying basically that our clients did in fact have these needs. And we won every one of those cases because ALJs really listen to doctors. So that's something to keep in mind. And it's also just really important to remember and to remind the ALJ that the FED, it wasn't created through a Regulatory Review Act process. It's not a regulation. It's not binding as a regulation. The definition is NFCE. The FED is only a tool to try to get at that, but the actual definition is the NFCE definition. So, any more questions at this point? Yeah.
We're just looking at the questions that have been submitted.
Okay. Kate question, is the old Aging Directive 2009 still controlling for the definition of NFCE? Yes. I need to look at that directive, but the definition has not changed, and so it should be, yes. Next question, Pam mentioned that assessors are supposed to ask whether people needed assistance in the last 3 days, not just whether they got assistance with various tasks, since they may not have been able to get the assistance they needed. Do we know whether that's happening? That's a great question. It's supposed to be happening. I think we don't know for sure. I don't think, we haven't been able to actually go to any assessments. If anyone has been able to be at one and has any sense, based on having seen something or heard their client describe it, that would be really, really useful information. We've kind of hammered home over and over with DHS that that has to be the way that it's being done, and the assessors have been trained that that's what they're supposed to ask. Are the CHC service coordinators using the feds to do the reassessments?
Yes, yes, they are. It's the same exact tool. It's just being administered by the service coordinators as opposed to the AAA assessors.
We have another question. How does the application for waivers administered by the Office of Behavioral Health differ from this process? It differs. It's a different standard. I actually don't know very much, frankly, about the behavioral health waivers, but it's a different standard, and the Fed is not used. So it's going to be a completely different process. Do ALJs understand the Fed? Did they receive any training on the Fed and how it is used to get to NFCE since there are no regs? This is such a great question. Unclear. They were supposed to receive training. We have actually not heard back from DHS that training has occurred. And that's something that we need to follow up with them about. They were supposed to have training on this, and I think that that's something that we're really just not sure of yet. Full disclosure, we've got 2 cases coming up, but we haven't actually done one of these hearings yet. Is there data about how many appeals have been filed and how many appeals resulted in an NFCE determination? If so, please share. I don't know the answer to this question. We can certainly ask it and share that information if we can get it with the group. What happens when someone is determined NFCE? Do they immediately get services, or is there a waiting period?
So that is a great question. If they are completely financially eligible, meaning that when their information went to the county assistance office, their income, they were within the income and resource limits, and there was no question about the transfer of assets during the 5-year look back, then their information would be sent to the MCO that they selected. So this is what could have happened during the initial call, during the first visit, and potentially during a follow-up phone call if for some reason they hadn't yet made a choice. Once it's at the MCO, they have 5 days to do a comprehensive needs assessment, which is the assessment that Pam described as being, it uses the Inter-RI home care assessment. So that's all 3 of the MCOs in Pennsylvania, Memorial Health Caritas / Keystone First in the Southeast, UPMC, NPA Health and Wellness, all use the Inter-RI, along with some other additional MCO-specific questions, but it's all based on the Inter-RI. Once that happens, the MCO has 30 days to get services in place, means, well, to have a completed person-centered service plan that is implemented. So ostensibly, you still have another 35 days maximum, potentially longer, unfortunately. We have seen some issues with this as part of the transition to CHC. So I would not say it's immediate. There should not be a long waiting period. However, if someone transferred assets that were subject to what's called a penalty period, then there could be a waiting period. So I realized earlier that I sort of misspoke. During the 5-year look back, the concern is transfer of assets for less than fair market value. So giving away cash, giving away part of your home, your whole home. People are allowed to spend their money. They're allowed to use it as they wish in terms of buying things, living, making improvements on their home, shopping, even gambling. It's really just when it's less than fair market value that the issue arises, and the penalty period is the amount of assets you gave away divided by the average monthly rate for a private nursing home, which for 2019 is somewhere in the $10,000 range, and that's how long you get the months for the penalty period. Okay. Sorry.
Just going to cover the last slide here quickly, and then we'll, if we have a couple more minutes, we'll finish the questions.
So we just put up a couple of issues that we've seen of so far that have raised concerns for us in terms of how the Fed is being administered. OLTL has been very, very clear that assessment should not take 10 to 15 minutes. Unfortunately, we do know that these are happening. One happened for my client very recently, where it really felt like the Fed was just being kind of quick check boxes off. That is not what this is supposed to look like. The Fed is a much more streamlined approach than the LCD, which was much more holistic, but that doesn't mean that it should take 10 to 15 minutes. If you hear of these happening, please, please, please let us know. Let P4A, which is the group that sort of oversees all the area agencies on aging, let OLTL know, let everybody know. That's really, really concerning and problematic. Just quickly while I'm talking, I'm going to touch on 2 of the other issues and then switch this back over to Pam. One thing we also have seen is people being assessed in a language which they are not comfortable with, which they have limited proficiency in. Some people might be able to speak a little bit in English, but they're really not comfortable talking about their needs extensively, especially some of the really private and personal information that the Fed covers. And we have heard of many situations in which clients are not being asked, what language are you comfortable with? Do you need an interpreter? And we have been able to go back and request a new Fed on the basis that it was not appropriate to do the Fed in English without a interpreter. Finally, I'll talk about one thing that we were concerned about before the Fed was implemented, and then we have had, I think, some reason to rightfully be concerned. Because the Fed breaks functional abilities into these categories and ties certain scoring metrics to it, we kind of played around with it to come up with situations where we could see someone who definitely meets the NFC definition, but would be found ineligible. And one example could be with someone who has full cognitive capacity, who has full cognitive capacity, so they're able to do certain things in terms of brushing their teeth and with the help of home modifications, getting in and out of the bathtub maybe, well, basic ADLs, but they still need the level of care that is determined to be NFCE based on the definition. And we played around with a couple of these. We thought of some situations, and I know that we have since seen them. So I think after maybe looking at the matrix and the Fed, everyone will kind of be able to see where these situations could arise. I think it's really important to think of people we're often used to seeing, older adult clients who are receiving these services, but there could be people who have significant mobility limitations and are very vulnerable in terms of being able to work to do certain situations whose needs might not be captured by the Fed. I'm going to turn this back over to Pam, and I know I do see we have another question. We'll get to those as soon as we finish in a few moments.
Another scenario that there's been concerns about is whether the Fed actually accurately captures the need of people with brain injury. And in fact, one of our first cases was a person with brain injury who the Fed just completely missed it. So these are all areas if people are seeing people who it seems to them should be NFCE, but the Fed just doesn't quite capture it. Or people who've been in nursing facilities for a period of time and are now being told that they're not NFCE, we'd really love to hear about those cases to help us explore whether there are more changes that need to be made that we should advocate for to the Fed. All right, so going back to the questions, here's a question. So do you end up settling most of these hearings by getting new assessments? How many actual hearings have gone to an ALJ decision? In my experience, the answer is yes. We have settled most of these by getting new assessments. Again, we haven't had any actual hearings yet with the Fed. I know other people around the state have had a few and can speak to this better than we can. But having done these with the old tool, what tends to happen once you get to the, first of all, we're able to settle a lot of them by getting new assessments. And if you get to the hearing, if you get to the point where you're putting on lots of evidence, and there tends to come a point where the judge will say, well, it really seems like this somehow didn't come out during the assessment. Wouldn't a new assessment really be a good way of handling this? And since it's another bite at the apple, which can be followed by another hearing if necessary, we've ended up going in that direction, and it was successful. So I haven't had one of these in a long time go to an ALJ decision. That's all the questions that we have here.
We have our contact information on this last slide. I know throughout this, we encouraged you to feel free to email us with questions. Again, I'm just going to reiterate that we're really happy to address any questions, and also excited to hear what experiences people across the state are having because of how new this is, and because of sort of how Pam mentioned, we've been able to resolve most of these by arguing why the new Fed is required and why it should be done properly. I do have a hearing coming up soon in an interesting case that kind of falls into a situation that I could imagine being problematic for the Fed, and yet someone who is NFCE, based on my understanding of the definition, which comes up to the last point I want to make. I know we're over time. The assessors are supposed to ask questions of caregivers if they are available. I know at least in one case where that is not happening, where a client of mine was receiving substantial informal support, and that person who was providing this very substantial 9 hours a day of support was not questioned at all. And sometimes people either forget exactly what they need help with or don't feel fully comfortable for a number of reasons. It's really important that people understand that other individuals in their lives who know about their functional abilities can be questioned, and they should be. So that was my last point. Thank you so much, everyone. We really appreciate you all joining us on this, and have a great Friday.
Thank you. Take care.